and it tested positive for methamphetamine. So that's why you're going to inpatient drug treatment.
This case starts like a routine plea hearing, but quickly spirals into a dramatic clash between addiction denial and courtroom reality. Meet Matthew Longoria, facing a felony theft charge with a criminal history that just won't quit. But what makes this courtroom moment stand out isn't just the charges, it's what happens after the plea deal is accepted. He's promised probation, drug court, and treatment. But the second the judge lays out the terms, Matthew flips the switch. Suddenly, he claims he doesn't even have a drug problem, right after admitting to heroin use just seconds earlier. Confused? So is the judge. And then things get even worse. What happens when a defendant tries to talk his way out of treatment, despite meth being found on him? What happens when the judge catches those contradictions in real time? Stick around, because this hearing is more than just a sentencing. It's a masterclass in courtroom patience, legal consequences, and what happens when denial meets hard evidence.
Court is calling 2024 CR 008934, State versus Matthew Longoria. Can I have parties announced for the record for the state?
Deputy Collector of the State of Texas, Your Honor.
Defense?
Thomas Hill is standing in for Attorney Douglas Kepmeyer with client's consent.
And are you Matthew Longoria?
Yes, Your Honor.
And do you consent to this attorney standing in?
Yes, Your Honor.
All right, Miss Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with Mr. Longoria?
Attorney Kepmeyer has, Your Honor.
Have you reviewed all the discovery with your attorney?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Longoria, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Longoria, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
You're charged with theft of property, $1,500, less than $1,500, with 2 or more previous convictions.
Here's where the legal weight kicks in. Theft under $1,500 might sound minor, but with 2 prior convictions, this bumps up to a state jail felony under Texas law. That means Longoria isn't just facing probation, he's looking at up to 2 years behind bars and a $10,000 fine. What makes this moment especially tense is that the court doesn't have to follow the plea bargain. It's a reminder that even when the state recommends leniency, the final call is always in the judge's hands. And Longoria? He seems cooperative now, but just wait until we get to the treatment conditions. Would you accept probation if it came with mandatory drug rehab? Let us know below.
Which makes it a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication, is there an application for deferred?
No, Your Honor.
All right. It's just that the paperwork says that. Let me see. Not your paperwork.
Douglas Kepmeyer informed me it was just before probation, Your Honor.
Okay. Any objections to the court just circling community supervision?
No objection.
Quick legal note here. The paperwork initially indicated a deferred adjudication, which would have kept Longoria's record clean if he completed the conditions. But that option is off the table. He's getting straight probation, which still keeps him out of jail, but a conviction will land on his record. That may sound like a technical detail, but it changes everything. Longoria's walking out with a felony conviction, assuming he complies. And that's not just about time served. It affects future employment, housing, and even his right to own a weapon. This is where the stakes quietly shift and the tension builds fast.
None from the state.
Okay. Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Longoria, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state is recommending community supervision. There's to be restitution to Walmart, no contact with any Walmart, the theft course, TAP evaluation, MRT, and 100 hours of community service restitution. Did you understand the theft course, the TAP evaluation, the MRT, and 100 hours of community service restitution, that part of your agreement, the court does not have to follow?
Yes, Your Honor.
All right, other than that, did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There'll be 100 hours of community service restitution and no contact with the complaining witness. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
just for the court to please respectfully go along with the plea bargain made.
All right, how long have you been using?
Drugs.
Yes.
In about 2 years.
And what have you been using?
Just heroin.
All right,
I've never shot up with the needle or anything like that.
all
It was
right.
just a dumb choice that I made.
All right, so here's the thing. I can tell you what's going to end up happening is that I'm going to place you on probation, but you're not going to be released from custody. The TAP evaluation is going to be done in custody. There's going to be a referral to felony drug court. And you need to be honest with them for that evaluation. And more likely than not, you're going into inpatient treatment. So if you don't want the inpatient treatment, now's the time to say so.
And here it is, the turning point. Longoria just told the court he doesn't want treatment. After admitting to heroin use, on the record, and being caught with meth, he's suddenly pulling the plug on inpatient rehab? This is the moment where you see the judge start recalculating, and not in his favor. It's like watching someone light their own parachute on fire midair. The court was ready to offer him structure, supervision, even support. And now he's about to throw it all away? What do you think? Is this self-sabotage or denial talking? Drop your thoughts in the comments.
I don't want the inpatient treatment.
All right, so do you want to discuss, do you just want to do 2 years in the state jail facility then?
No.
I mean, you're going to end up doing times, or either you're going to follow the court's recommendations.
It's on probation?
Mhm.
I'll follow the probation.
All right, so the court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There is going to be SafeP, so you're going to SafeP. That's an inpatient drug treatment. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be proof of employment within 45 days of release, no employment as a home health care provider or with minors. There's to be 200 hours of community service restitution. There's to be no contact with Walmart. There's to be no contact with minors.
This isn't your average probation. Judge just dropped a 5-year suspended sentence, plus inpatient treatment, 200 hours of community service, a complete ban on Walmart, and, this part stands out, no contact with minors. That last detail is jarring. It implies the court found something in the file that raised a serious red flag. Add that to the meth, theft, and drug denial, and suddenly this plea deal feels a lot heavier than it first appeared. This isn't just rehabilitation, it's restriction. Longoria's life is going to be monitored, managed, and evaluated hard. Would you take this deal if it meant staying out of jail?
There's to be the theft course. Probation, is there anything else? There's to be field visits 1 time per month until further notice. And he's to remain in custody until transferred to safety. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I'm not trying to be dumb or anything. I don't understand what's going on if I was gonna get probation.
No, I gave you probation, but you need treatment for your drug problem.
I don't
That's
have a
right.
drug problem.
Okay, then you're just stealing for no reason.
I don't have a drug problem.
So that means you're just stealing for no reason.
It was just dumb choices. I don't
Right.
have any kind of drug problem.
So here's the thing. I've given you a legal sentence. If you do not want to sign for SafeP, let me know and they'll file a motion to revoke. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. So what I can tell you, the conversation you had with me, you tell me you were using heroin. What I read in the police report, when they had the stolen items with you that they recovered, they mentioned also, I contacted Detective Burban and advised him of S1's arrest. CSI Worthington field tested the substance that you had and it tested positive for methamphetamine.
So let's break this down. Matthew Longoria walked in thinking he was getting standard probation. But the moment he tried to deny his drug problem, despite admitting heroin use and testing positive for meth, the judge didn't blink. Instead, she laid out a strict, legally binding sentence: inpatient rehab, long-term probation, public service, and 0 contact with key risk factors. No more excuses. No more spin. This was about accountability, and the court made it crystal clear. This hearing is a reminder that words in court matter, especially when your actions already speak louder. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. New cases every week. You don't want to miss what's next.